plaintiff did serve a second amended complaint. I would consider the document you have before you a third amended complaint. Whatever amended complaint we're dealing with this motion. Bryant, the latest document is March the 20th. That's the plaintiff's present pleadings. Kalaji, fine, and we'll address this motion to that. Your Honor, Kalaji says, we've got a situation where the claims that are asserted in the amended pleading before you are the very same claims that were before Judge Broderick. Judge Broderick, in a decision where he considered the claims relating to Section 531, that's no cable operator shall exercise editorial control over public use of channel. Relating to Section 531, ruled that plaintiff did not have a private cause of action. Plaintiff appealed that order to the Second Circuit, and the Second Circuit unanimously affirmed Judge Broderick's decision and order. This is Kalaji. Plaintiff then commenced an action in state court. You'll remember, Your Honor. You had the first case, and you ruled that while plaintiff could not state a claim, there might be some state claims that she could bring across the street, and she did. He's got these all mixed up. The first lawsuit against Cablevision was in Bryant's court. The second one was in state court, Judge Silverman's court. The third one was in Broderick's court. So Kalaji has them all mixed up, and it's not exactly mixed up, it's just lying. And she brought an action there, and Judge Silverman was a judge who was assigned to the case, and all of the claims that were not only in the federal case, but additional state claims were asserted, and after full briefing and after argument, Judge Silverman dismissed all of the claims. Well, Kalaji says after full briefing, but you ought to, you know what Kalaji said in his respondent's brief to the appellate division. He said they weren't fully briefed, that he never got a chance to produce evidence. Remember? So he just lies from one court to the other. And after argument, Judge Silverman dismissed all of the claims, even though he didn't have to. He did say that the defendants were not state actors and plaintiff had no claim, even though that had already been ruled upon in the federal court. And Judge Silverman ruled that with respect to her claim that she should not have been taken off the Long Island cable system, that the statute said that only for obscenity could someone be taken off, and he ruled that she should be put back on, and she was put back on and has been on till this day. Bryant, well, she was off for a period of time. Glendora, 11 months. Bryant, and if she has rights under the statute or Constitution or both, she lost the benefit of those rights. They have at least the value of $1, and they might have a greater value than that. So it seems to me that she has a claim left unresolved even after Justice Silverman's order. And Bryant continues, a more interesting issue is the issue of the apparent cavalier disregard which the second panel of the Second Circuit expressed towards the panel of the Second Circuit, which was first in time, and I think that's essentially what your motions are directed towards. He's talking about the Broderick. There's a Second Circuit affirmed Broderick's bad decision. But the court has somewhat of a problem, much like that of the soldier in the army, who must obey the last order of the last officer who happens to give him an order. Bryant continues, and it's really rather bizarre that the second panel would ignore the legal theory of the first panel. That would be the one that ruled on the Judge Bryant decision. That's the first panel. And suggests that there probably is an implied claim under the statute, when by affirming Judge Broderick, the first panel, point of time, had expressly told the world there is not. That's what I said from the beginning. But I don't think there's much you can do about that at this point and in this forum, Bryant tells Kalaji. Kalaji, Judge, a couple of things. First of all, the plaintiff is appealing the unanimous affirmance of the Judge Broderick decision and order to the United States Supreme Court. She has filed for a petition for cert there. And Bryant chuckles. And he says, lots of luck. If you know how to get a petition for cert out of the Second Circuit, I'd like to find out, because they're generally denied. He's right, but it still could happen. Kalaji, I think so. Bryant, especially when they're pro se. You know that. Kalaji, I know that. She is also appealing the order of Judge Silverman, which dismissed all of her claims except the one claim relating to whether she was entitled to be put back on. Now that's wrong. Not only did Silverman say I should go back onto TV and put me back onto TV, but Silverman also said that the constitutional rights of Cablevision were not denied, and he ruled something else. What was that? Oh, that the New York state cable television rules are not preempted by federal law. Okay, Kalaji continues, and that's currently been fully briefed and is before the Appellate Division, 2nd Department. Well, he's wrong about that. I'm in the middle of writing the reply brief when he says it's fully briefed. It's not fully briefed. And then after I write the reply brief and hand it in, as I did last Friday, Kalaji has to get out a respondent's so-called reply brief. As far as the Kalaji continues, what the Second Circuit did from your order, as I read the statute talks about quote unquote may, there is nothing, no cases I'm aware of which mandate a private cause of action for a party like the plaintiff. Brian, that's a litigable. That's a litigable issue, and frankly, it looked to me, take this slowly, as if the Second Circuit has directed this court to address that issue. And we are fortunate to have skilled counsel as amicus curiae. And I think that's the kind of issue the court would have to have a full submission to reach a conclusion of law. So you see, this is how this case is making law. Isn't that right, Katie? This makes Katie pound her tail. Kalaji. Well, maybe in view of your Honor's suggestion that we ought to wait to see what the Appellate Division... Aha! Brian, I never made that decision. I never made that suggestion. Brian said, I never made that suggestion. Kalaji, no, I'm making that suggestion. Because you know, that issue is squarely at center in the appeal in the Appellate Division, 2nd Department. I mean, as your Honor knows, and we've submitted various of the franchise agreements, they all talk about a member of the community. There's no dispute plaintiff in her paper says she lives in White Plains. She is in Westchester County. She has no connection with Western Suffolk County or Nassau County, and that's what the issue is. Glendora tells you she has a huge connection, Scott Lord. And the negligence of Judges Hall and Duberstein, and of the United States Attorney, and of the United States Trustee, and of Joseph Derby, and Jan Stahl, and Jeffrey Barnes. Huge connection. Back to Kalaji. Every single agreement talks about a person having public access who was in the community, and she, in her own paper, says she's not in there, and really what we're dealing with is somebody who admittedly is resourceful, but can take her car out to these municipalities where she has no connection whatsoever and say, I want to air this. Well, this happens to be the law, Kalaji. It has nothing to do whether you're a member of the community or not. And yet that's not what the franchise agreement talks about. They all say the same thing. It provides access for the public within the municipality, and she's not within it, and that's a lie. She is within it. And Cablevision knew that when they put a chat with Glendora on TV in Nassau County. They signed a contract with me. They had me take the public access workshop. They offered me editing time and made several appointments to edit a chat with Glendora there. They had me go out and find a local sponsor, a person in the community who knew me, so I was the public within. This argument of Kalaji's fails. That's one of the issues the Appellate Division, Kalaji goes on to say, 2nd Department is going to pass on, is whether, as a matter of statutory interpretation, a plaintiff who is not within the community, again, I am within the community, and that was the whole purpose for the scheme when it was set up, to provide access for local residents to be on cable, and she is not a local resident. She has never been taken off the Westchester system. Throughout all this litigation, we kept her on that system because she was a resident of White Plains. This is a lie. These are all afterthoughts. You know, this comes after the Model T has been stolen and the barn door has closed after the Model T is stolen. She is a resident of Westchester County where we have systems, and we've kept her on. Well, Kalaji says we. He's not Cablevision. He's Sadley, Stevens, Burke, and Burke at 230 Park Avenue. He's not Cablevision. He shouldn't say we. And so Bryant says to Kalaji, did Justice Silverman address the part of the issue where she lived? Kalaji, he didn't know. He did not address that issue. He said she had no cause of action for damages. She was not a state actor. She was not a state actor? No. He said they were not state actors. Brian, what's the basis for putting her back on? Kalaji, on the basis that absent evidence that her show was obscene, you could not in any way exercise any editorial control. One of our arguments was we were concerned about a trademark suit by which the statute implied admits is a legitimate concern, but it is not. She goes on the air with an NBC logo. This is not an NBC logo. These are just letters. And I don't go on the air. I go on the cable. She has no affiliation whatever with NBC. That's wrong. I'm a customer of NBC. I bought about $100,000 airtime from NBC. Her correspondence she shows on the air, and I'm not on the air, I'm on the cable, says ABC and NBC, and place even right on the correspondence. She has no affiliation with these stations or networks. Wrong. I'm a customer of all of them. We were concerned not only about the fact she's not a local resident in Western Suffolk or Nassau, but we were concerned about trademark issues. That's stupid. And it's also desperate. Your Honor, those were the reasons why in those localities she was removed. Baloney it was. The reason is that she was telling the truth about Nassau County politicals and judges, and that's why, and they called up Cablevision and exercised pressure and said, get her off. And so Cablevision, in its arrogance and ignorance, did. It's our feeling, Kalaji goes on to say, based on the statute, in situations where there is a private right of action, the statute provides for, but in this area there's absolutely no mention whatsoever in the statute that would afford someone a specific private right of action under these circumstances. Brian, all this information was directly before the what I might refer to for convenience, the Van Grafelen panel of the Court of Appeals. They knew all this when they wrote the opinion on remand. Isn't that true? Kalaji, I don't know that they knew what had happened from the panel on Judge Broderick's opinion. We had supplied a copy to the court. Bryant, before I tell you what Bryant said, that's a dumb thing that Kalaji said, because McLaughlin was on both panels. McLaughlin was both panels, and Kalaji says, I don't know that they knew what had happened from the panel on Judge Broderick's opinion. Bryant says, it would be rather shocking if they didn't. But you see, a district court cannot police a panel of the Second Circuit as to the degree of respect or consideration to be given to the decisions of a panel of equal standing consisting of 3 other judges. It may be that on a motion to recall the mandate, this is Judge Bryant, assuming they didn't know that they might correct themselves, but this court is in no position jurisdictionally to do anything about the fact that the opinion prior in time appears inconsistent with the opinion in this case. And you've also got a state order, which again comes to the same conclusion as Judge Broderick and as the appellate panel. Don't place me in a position of defending the panel. Kalaji, but all I'm suggesting is that maybe the appropriate way to proceed would be to state consideration of this issue until after the appellate division. Brian, the panel didn't tell me to stay it. Panel being the Second Circuit. The panel didn't tell me to stay it, and I think I'm in a position where I think I ought to answer the question they sent back to resolve. I don't think I'm prepared to do it today, Judge Bryant says. I appreciate the fact that the amicus are here, and I gather they want to submit something. Undoubtedly, that they submit, what they submit would be more germane than any kind of information a court can get from a pro se litigant. So I think what we should really do, we ought to hear what they want to say, and maybe I'll take briefs on this issue of whether the court should make a finding on the issue of whether there exists an implied claim under the Cable Act, what the Court of Appeals has flagged us to do. And Bryant continues, frankly, in the manner by which they've done it, they've all but suggested, that's the Second Circuit, that they think there probably is, because I'm sure, let me go, there's probably is what? Go back to what he said. Of whether the court should make a finding on the issue of whether there exists an implied right of claim. Do I have a private right of action to enforce 531E? No cable operator shall exercise editorial control over public use of channel. Now, that's what he's saying, that he thinks that the Second Circuit all but suggested that they think there probably is a private right of action. Okay, now Bryant goes on, he says, because I'm sure that a panel of the distinguished Second Circuit Court of Appeals won't send a case back to a busy court for pure futility. Kalaji, I don't know that I'd go that far, but Bryant, it's hard to go that far, but you have briefed that issue as well in your papers. Bryant, well, why don't I hear from your friends, the amicus curiae? If you want to say anything further, you may be heard before we leave, he says to Kalaji. All right, thanks, Judge. Kalaji sits. Grafman, Your Honor, I would suggest, Bryant, you're Mr. Grafman. Mr. Grafman of Cairo and Grafman. This is Professor Perry, and I would suggest that may I address some of the procedural points that might be of help to the court, and Professor Perry, being the expert in First Amendment law in this area. Bryant, I really think that you ought to give me your litigating position and perhaps favor us with a memorandum of brief if you wish to do that. Grafman, we would. Bryant, I think extensive discussion at this point may not be of great help. I'm not cutting you off in advance. Grafman, I tend to agree with Your Honor. If I look down the list and see if there's any other points I need to make that would come outside, I think everything I have to address could be addressed in a submission. Bryant, I think that the submission should be limited to the issue of whether there exists an implied private claim under the statute, and if so, whether the posture of this litigation permits Glendora to litigate that claim under these circumstances. Perry, may I be heard? Bryant, certainly. Perry, my name is Robert Perry. There are actually several other claims here, First Amendment claims. As you know, Your Honor dismissed the case earlier because Glendora had failed clearly to state claims, state action, but we believe, and Bryant, the Second Circuit didn't endorse that one, did they? Perry, they didn't endorse it, but at the same time, they didn't explicitly reject it. I would ask Your Honor if we can brief the issue. Bryant, if they regarded that as a valid claim, there was no need to go off into the thicket of the issue of whether there's an implied cause of action under a federal statute. Bryant really gets out some very fine expressions. He's really quite articulate. Okay, Bryant continues. Lately, such implied causes of action have been somewhat unpopular with the Supreme Court. It came to me as somewhat of a surprise to see that the authors of the Van Grafelen opinion clearly think there probably is. There probably is an implied right of action for me to enforce 531E. No cable operator shall exercise editorial control over public use of channel. Perry, I believe there is, Your Honor. I successfully litigated one of these cases under Section 531E in the Midwest. But I would ask Your Honor if we could brief at least the constitutional question as well. Bryant, you can. But if that were a valid claim, you had no need to get into this other issue. It's still not been held that these people are state actors. And if they are, you know, supposing they fired Connie Chung, can she claim that she was a First Amendment violation? Perry, this is a special set of facts, Your Honor. There are two series of state facts present. First, Glendora does, in the second amended complaint, allege official pressure to cancel her program. Bryant, the official pressures, number one, they're not defendants. And secondly, I think a person has a right to call up and protest the statements of Connie Chung to the network if I want to do so, if I'm a private person or a public person. Perry, I understand that, but this is not simply a private caller. This is perhaps a call, allegedly a call, or maybe a few communications from Nassau County officials who are perhaps irate about Bryant. The most they did, they violated the First Amendment rights or attempted to of the owner of the station or the editor of the station. Perry, the cable system here in question. Bryant, the cable system. You can call it whatever you want. It's a media device authority. Well, there's a huge difference between a broadcast station and a cable TV operator. Huge. Perry, it's a franchising authority which periodically decides on renewing the franchises, so there is some stick. Bryant, she may not be the victim of that violation. MS Glendora may not be the victim. Perry, she's the speaker, and she was censored from the public access channel. I would submit she is the victim. Bryant, you have a right to brief that issue, of course. Perry, the second issue, state action issue you have, I'll mention and sit down, is simply that public access channels, we argue, are an electronic public forum, no different from the parks, the streets, and the sidewalks. When Cablevision administers and operates the public access channel, it is engaged in an exclusively governmental function, exclusively public function. In that respect, the editorial control of such channels is state action. I just mentioned these two theories, and that will be it. Bryant, now assuming that the court finds in favor of you, favor of the plaintiff on either of these three different theories, what is the remedy to which you would be entitled to on the present state of the record and in light of all her other litigation? Perry, I believe, Your Honor, there is the outstanding damage claim. Yes, she is back on the air, but she does have her damage claim, and I believe there is not only a question of compensatory damages, and I have no idea what those damages are at this time. As I understand it, would be what a jury would say, it is not an economic undertaking. There is also an intentional violation of her guaranteed federal rights under the federal Constitution. Bryant, that can give you nominal damages. Perry, it also could lead to punitive damages, Your Honor. Let me see now if this is in sequence. These got put together wrong. That is certainly page 16. This is certainly page 17, and it's upside down. A few things are upside down. Grafman, may I add one thing? Bryant, you ought not to have interrupted your fellow friend. Perry, he can do that anytime he wants. Bryant, I think the injunctive aspect of this case is now moot because it is the decision of Justice Silverman. It's being appealed in the state forum by Cablevision, and it's possible they tell me the second department applies the same Constitution. I hope that was so. Grafman, that's correct, but I think one forum, and I think Professor Perry has a case cite to this one. You shouldn't, Bryant, if there is punitive damages awarded, you don't need an injunction. Grafman, I mean after injunction to keep her on the air, because if they win on appeal in the other forum on the state issues, she still will have, if they take her off the air, I'm saying it's still a case of controversy, she will be Bryant. By your theory, they took her off the air and subjected themselves to compensatory and punitive damages. That's your theory. If that's true, and she prevails on that, there's no reason to believe they're ever going to take her off the air again because it costs too much. There's an adequate remedy at law. Grafman, I would tend to disagree in the issues that if her First Amendment rights are violated, then that's a unique, Bryant, She collects damages for them, and they will never do it again if that occurs. You don't give injunctive relief except if there's no adequate remedy at law, because there would have to be some belief on the part of the court they're going to do it again. I think their position was they did it under claim of right. Now that the Second Circuit has told them, if they do tell them that you can't do it, of course, they're law-abiding people and pay their damages and go on about their business and not do it again. I'm going to ask you to propose when you could have this matter fully submitted on these issues that would remain open. I think the court will deal with the collateral estoppel issue and the issue of mootness at this time, and I don't know if Mr. Kalaji has something else he wants to say. Glendora, I do, Your Honor. I have something to say. Kalaji, Your Honor, again, to the extent that you set a briefing schedule, I would like to have an opportunity to reply. I don't have anything further to say on the issue. I do feel that on the issue of collateral estoppel, whether the Van Grapelen panel was aware or not, the fact that we have an outstanding opinion of the Second Circuit which covers the very issue, this very issue to me, does operate. Brian, frankly, if I were a practicing lawyer, I would be somewhat irate over it, because it would lead me to believe that somebody didn't read everything that should have been read. How many times have I told you that? But that's not the kind of a problem, Bryant continues, which can be redressed in the district court. And possibly if someone went and either moved for a rehearing en banc on the ground that the second panel showed lack of respect for the prior panel's decision, or on the ground that they couldn't have really meant to do it, or they didn't know about it, or were too busy and weren't paying attention, and all of that stuff, which may or may not be true, that's not something I can do. That's a matter for litigants to consider. I think I should make a ruling on those two items, and I'll leave open the other issues and a date for briefing, and the defendants can give responsive briefs. Glendora, may I say something, Judge Bryant? Bryant, yes, it's largely a legal issue, as I'm sure you understand. I think I should make a ruling on those two items, and I'll leave open the other issues and a date for briefing, and the defendants can give responsive briefs. Glendora, may I say something, Judge Bryant? Bryant, yes, it's largely a legal issue, as I'm sure you understand. Glendora, what did you say? Bryant, it's a legal issue we're talking about this morning. Glendora, Judge Bryant, about this copyright, Mr. Kalaji is wrong. This is not an NBC logo. This just happens to be letters. It is not an NBC logo. He's been telling that lie in 5 courts. Bryant, has NBC ever sued you? Have they ever written a cease and desist letter? Glendora, never. Maybe, Bryant, maybe they think it means National Biscuit Company. Glendora, I'm tired of that lie. I wish you would. It says, see Glendora on NBC. I have bought something like $100,000 of their airtime. That's my business. Glendora TV ads enables people to advertise on TV. I specialize in television. That is my own business. That's how I make my living, or used to, until Cablevision took away 75% of my life. I'd like to say something else, Judge Bryant, that it is wrong. I submitted 3 amended complaints. Bryant, this is your present complaint. It's March 20th filing. Is that right, Glendora? That's my 2nd amended complaint you asked me to submit. Bryant, that's presently before the court? Glendora, it's before the court, but he didn't respond to it. He responded to something I never submitted. Bryant, his motion is being treated as directed toward this paper? Perry, well, no, I don't think it is. If you read his paper, he never addressed this complaint at all. Bryant, the underlying issues present here are being addressed, and it really wouldn't matter which complaint. Glendora, oh yes it does, because we raised some very significant points in that complaint. The things you were just discussing, so he is responding to the wrong complaint, and I don't know how he ever got it unsigned, unsubmitted, and notarized. Brian, I'm treating the motion as directed to document number 42. Glendora, and now Judge Brian, I got this complaint yesterday at 3 o'clock. Excuse me, I got his so-called reply affidavit yesterday at 3 p.m. I got up this morning at 1:40 a.m. to respond to it, and I worked on it until 8:10 a.m. when I had to come here. I want your permission, please, Judge Bryant, to respond to that. Brian, you can respond also, but please let me make it clear to you that at this particular stage of this litigation, we're concerned with one of three somewhat esoteric issues of law, and you're very fortunate. We've got these two amicus curiae here, who each one wants to interrupt the other, but they're working together, and you've got a skilled lawyer on the other side. Glendora, I question that. He's talking about Kalaji. He says he's a skilled lawyer. Glendora says, I question that. Brian, well, the court is trying to resolve these purely legal issues, and you have the absolute right to do that. But you shouldn't lose any sleep doing it, because, frankly, a person who has a watchdog shouldn't do his or her own barking. Glendora, that's pretty good. Can I quote you on TV? Brian, I suppose you can quote anything on TV. You have First Amendment rights. Glendora, I'm opposing it because it is filled with lies. It is filled with half-truths. Brian, right now we're addressing a legal issue. Glendora, okay, all right. Brian, eventually, if you prevail on your legal issue, you will have a right to be heard by a jury on your damages. That's a different story. Glendora, Judge Bryant, he handed in a thing this thick with franchises, and he's trying to maintain that I can't go on those cable systems in Nassau because I don't live there. Now, that's just not the law. And besides, it was Cablevision who put me on those systems. I went through all their processes. I found a local sponsor, so I have to come in under the public within quote unquote. I found a local sponsor. They told me to, so I'm there. Brian, who's a local sponsor? Glendora, a person who lives in Long Island. Brian, do they pay any money? Glendora, it can be anyone in Long Island. Brian, they don't pay anyone money? Glendora, it's a subsidiary. No, I didn't say that. I don't know. That's a stenographer's mistake. Anyway, there's no money in public access. It's not that kind of a sponsor. Brian, what is the sponsor's responsibilities? Glendora, just that she knows me. I have to know somebody in Long Island, and this particular person I chose. Brian, why don't you submit a copy of that? Glendora, okay. Brian, and also, Your Honor, oh, excuse me. No, that's wrong. That's another stenographer's error. Let me figure it out. It's Glendora who says, and also, Your Honor, they put me on the cable TV. I went through, I signed their contract with them, and yesterday, the bottom there, just yesterday, I got my renewed contract. I signed a contract with Cablevision, public access contract. It just came in, the renewal just came in. I signed a contract with them originally, so they're fully aware of what their franchises say, and what you fully aware of all the rules, and they accepted me. So he has no argument there, and this great big page like that, it's a rehash of what he's handing into the appellate division. He says that the appellate division matter is now, I believed it is not brief. I am in the middle of writing my appellate reply briefs. After that, he gets 10 days to answer it. It is not fully brief. You say they are law-abiding citizens, Brian. I'm saying that the station owners, they're not station owners, they're cable TV operators, presumed to be a law-abiding citizen. Glendora, cable TV operators. Brian, all right, cable TV operators. You can use any lingo you want. Glendora, I'm sorry about that, Judge Brian. I've done nothing but television all my life. I started out in broadcast television 30 years, a big difference between broadcast and cablecast. Brian, what is the difference from the point of view of the First Amendment? Glendora, I don't want to get into that. I'll be glad to answer in writing. There is a difference. He's already trying to get me off the cable TV. You said they're law-abiding, told to put me back, did put me back. They're going to leave me there. Well, Brian, courts avoid entering in an injunction if it isn't necessary, and one of the reasons they do that is if the wrongdoing should reoccur, the courthouse is always open to give injunctive relief. So ordinarily, we take a position that declaratory relief and damages are adequate. Glendora, fine. Why is he trying to get me off again? saying I don't live out there. Bryant, I think he has the view that this is a legally significant issue. Everything we're talking about this morning is purely, at this stage of this litigation, an issue of law. Glendora, an issue of law. Okay, Judge Bryant. Bryant, there may come a time in the case when the issues will not be purely legal issues. Glendora, thank you for having me back. I want to ask you, how long are you going to give me to answer the thing that I received last night? Bryant, first I'm going to ask the amicus curiae how long they want, and I'm hoping you can do the same as they do. Glendora, I can have mine in tomorrow, Saturday. Bryant, that's fine. I'll take it tomorrow, except it's Saturday tomorrow. Grafman, could we have 1 month, Your Honor, in light of our... Bryant, yes, but that should be about the outside. I think so, too. They should get it in sooner. Grafman, I recognize that. Bryant, of course you may get mooted by the second department or somebody else. If they give it to you in a month, when will you answer? He says to Kalaji. Kalaji say, I would say 2 weeks after that. Bryant, the clerk will give you the date in which all papers concerning this particular issue we're talking about, or these 3 issues, shall be fully submitted to the court, and that will be May 8th. Do you know what the 3 issues are? Well, I think one is, did they violate 531E? A cable operator can't exercise editorial control over public use of channel. And 2, do I have a private right to enforce it? And 3, were my civil rights violated? Now, the court wishes to deal with parts of the motion. The motion to dismiss has, with permission of the court, been deemed applied to the current pleading, which is document number 42, filed March the 20th in this court. Essentially, this motion seeks to dismiss the prior complaint and now this complaint, and indeed any complaint that could be filed in this lawsuit at its present stage, on the grounds that the claims are collaterally estopped, and that the issues raised are moot, and that they fail to state a claim. Because there's no implied cause of action under the Federal Cable Act, and no direct First Amendment action under the facts pleaded. The court has previously admitted the amicus curiae to continue as such in light of their participation in the proceedings before the Court of Appeals of the Second Circuit and Glendora versus Cablevision Systems Corporation, 94-7289, decided by the Court of Appeals by a panel of the Court of Appeals in the Second Circuit on January 11, 1995. I think for convenience that can be referred to as the Van Grafelen panel. Van Grafelen's hard to spell. V-A-N, capital G-R, double A, F-E-I-L-A-N-D. And we'll consider, Judge Bryant continues, first, the issue of collateral estoppel, which of course should prevent the relitigation of issues of ultimate fact between the same parties or ultimate issues of law when they have been determined by a prior, final, and valid judgment. There was another case in this court resulting in a decision by Judge Broderick entitled Glendora against Dolan. That's Exhibit E attached to the notice of motion, and the only citation I have for it here is 1994 Westlaw 719160. And in that action, familiarity with which is assumed, Judge Broderick found that her complaint should be dismissed as res judicata and that there was no implied cause of action under the Cable Act. The Court of Appeals of the Second Circuit, by a different panel, affirmed Judge Broderick. That affirmance took place on December 2nd, 1994, which is prior in time to the decision of the Van Grafelen panel in January of 1995. This court finds that the second panel in the Court of Appeals had at least constructive notice of the decision of the Court of Appeals panel of December 2nd, 1994, and there's a reason to think that they may have had actual notice. This court must be responsive to the mandate in this particular case and to the Court of Appeals panel on January 11, 1995, which remanded this case stating that there was an unanswered question whether Section 531E of the Cable Act was applicable, and if so, by whom it may be enforced, and specifically whether this violation of Section 531E gives right to a private federal cause of action. So that's the order of our Court of Appeals, and the District Court must act in full compliance with remand. It's not for this court to say that the remand is improper because it does not show adequate respect for the December decision of another panel of the Court of Appeals. This court, in responding to the remand, concludes that Glendora's claims under the statute are not barred by collateral estoppel, although on the surface of it, it would seem that they should have been. The court's conclusion in this regard does not consider in any way whether and when and to what extent the Court of Appeals acting en banc can straighten out apparent inconsistencies between panel opinions, or whether the second panel, in point of time, fully confronted with the issue, would have perhaps modified its views. Those are not matters of my concern, and this court will be totally responsive to the mandate in this particular case as I am required by law to be. This is Judge Bryant giving his decisions. The court also concludes that the amended complaint is not moot. The broadcast or the show or whatever you want to call it has been restored to the cable, but there is the remaining issue of damages for the period of time during which there were no distributions of the show, and while this might only lead to recovery of $1 in nominal damages, conceivably might be more. The existence of the right to nominal damages prevents mootness. Judge Bryant continues, there is also open as of the present time whether other claims survive here or exist here and are actionable under this amended complaint, apart from or in addition to the claim under Title 47. That's, again, no cable operator shall exercise editorial control of public usage channel. Under Title 47 for implied cause of action, and that includes but is not limited to claims possibly arising directly under the First Amendment of the Constitution. The court denies that portion of the defendant's motion to dismiss with respect to the claim of collateral estoppel and mootness. The court reserves decision on the portion of the motion directed to the issue of whether a private claim exists under Section 531E, you know what that is now, and to the balance of the claims pleaded under this amended pleading, and which the court will decide after receiving and considering further written admissions from the plaintiff, the defendant, and the amicus curiae. The foregoing constitutes a partial decision of the issues presented in the motion here today. If there is some point that has not been covered or which does not give an adequate record to you for future administration of this litigation, you can ask for additional findings or conclusions at this time, and I think I'll begin with the amicus if you have any requests. Perry. No, Your Honor. We're fine. Kalagi. Bryant. Mr. Kalagi. Kalagi. I think you covered it, Judge Bryant. Bryant. And Ms. Glendora. Glendora. I'm not sure, Your Honor, but I wish to thank you for being here today. Bryant. I'm sorry? Glendora. I'm not sure about additional things. Bryant. Put it in your paper if you have any. Glendora. Okay. Put it in my paper. Bryant. Okay. Glendora, before I go, I want to say thank you. Brian, you're not supposed to do that because the court is doing its duty under the law and the Constitution, and I'm not supposed to be thanked. And then he says, thank you very much. At 10:19 a.m., the proceedings were concluded. And here's the certificate of Angela O'Donnell, a registered professional reporter, and this cost me $99. $3.30 a page. You think that's right? That's another issue. But anyway, we've got a lot to think about what Judge Bryant said. Haven't we? Well, think about it, Katie. Katie, I don't think you are thinking. No. I don't think you are thinking, Katie. Right after that, Kalagi wrote a letter to Judge Bryant and asked Judge Bryant for a stay and for an interlocutory appeal in the Second Circuit, to go back to the Second Circuit. And as I told you about Kalagi always before, he never has any kind of a defense and no merits in a court that he's in. And he's always wants to be talking about another court or going to another court or getting a stay because it's in another court, because he has no defense. He just has no defense. It's obvious he has no defense. And he can feel that crushing in upon him. And I told you last week that Judge Bryant immediately got out his order or his endorsement saying that this court declines to grant an interlocutory appeal. So Kalagi has to come back and face it. He's not going to get out of it. Because Judge Bryant says that by law, this is what the Second Circuit mandated him to do. I'll say to you that this whole thing of minutes and stenographers is a ripoff. The courts are not an industry. The courts are not a place where lawyers and court stenographers go to see how much money they can make. Courts are not an industry. Courts are supposed to do with justice. So a person should be allowed to go into the courtroom with his tape recorder, and he should be able to make an accurate record of what happens in the courtroom. And then the person should go out and get it transcribed and have it settled. And this would cost something like $5 or $6. I shouldn't be ripped off for $99 to pay for those minutes. Now, this is April the 20th. In 5 days, Graceman and Perry, you know, I got mine in long ago. I read it to you. It was called a survey reply. I read it to you. So I got it in the next, right after that. You can't have these papers hanging around. It will ruin your life. So you have to get them out. Stay tuned if you want to. I don't know whether you want to or not. So that's Glendora versus Cablevision lawsuit 1 on remand in the court of Judge Bryant, United States District Court, Southern District of New York. Now, Glendora versus Cablevision lawsuit 2, my reply brief was submitted a week ago tomorrow. Kalaji has to answer that with a reply brief. And that'll be it. He has the last word, and then you'll wait a year. No, the amici have to submit a brief. Have to ask the appellate division for leave to intervene as amici, or to submit a brief. And then that's it. You won't hear anything from that for a year. The appellate division is a year behind. They used to be a year and a half behind, so things are better. On lawsuit 3, I have to back up here. On lawsuit 2, there's something else that happened. Judge Silverman did not sign the second order to rob Glendora of her costs. The victor is supposed to get the costs awarded to same, and I have $695 costs come to me, and believe me, that's low. That's a low price. It could have been a lot more. And it certainly cost me a lot more. And then Judge Silverman signed the first order to rob me of my costs. And then I went out and sent the sheriff after Cablevision again because it applied just to the date of August 23rd. And then Cheap, Grubby, Kalaji, Satterley, Stevens, Burke, and Burke, Strickland got Judge Silverman to sign another order to show cause to rob me of my costs a second time. And so Judge Silverman had until April 15th to sign that, and he didn't sign it. And the law says, CPLR 2219, that a decision has to be given within 60 days from the time that the motion is submitted. So he missed it. Judge Silverman missed it. So what you see here is going to the county sheriff today, the Westchester County Sheriff, that is, not the Nassau County Sheriff. That's going to the county sheriff today to reactivate the sheriff to go over to Portchester, New York, and go to the Bank of New York, and go to the account AR Cable Services of New York Incorporated. That's another name that Cablevision operates under. As I say, they have about 30 different names they operate under. And to collect that money and give me the check, and also to include the fees and the poundage and everything else. So that goes to the sheriff this afternoon at 1:30. Anything else in Cablevision? Yeah, Cablevision 3, Glendora versus Charles Dolan et al. Is in the United States Supreme Court, and I haven't heard from them. And that's a whole mess. Just as Judge Bryant said, the Second Circuit's decision on the third lawsuit is really in conflict with her decision on the first one. And also, Cablevision clearly broke a federal law, and there is no dispute of facts, so maybe the United States Supreme Court will do something with that. We just have to see. How would you like to have that many things to do in a day? The to-do lists are getting better, but they're still a nightmare, or a daymare. And now it's time for some jokes. Gwendolyn said, "I used to be miserable and depressed, but in the past 6 months I've turned that all around." "Good." She says, "Yes, now I'm depressed and miserable." And somebody said to Dolly, "What do you think of red china?" Dolly says, "It's okay as long as it doesn't clash with the tablecloth." And Stephen wanted to go to a meeting of Paranoid Anonymous, but they wouldn't tell him where they held the meetings. As to what is happening on Gannett, Glendora versus Gannett, John Curley, Douglas McCorkindale, Gary Watson, who's the president of the newspaper division, Gary Sherlock, who's the person to blame for everything that goes wrong in Westchester County, Rockland, and Putnam. That's Gannett Suburban Newspapers, and his executive editor, so-called Kenneth Paulson, which was all started by the Mitch Broder with his prima donna. "I just may not write this story." What happened there on this week? As you know, the Gannett annual meeting is coming up May the 2nd. It's in Arlington, Virginia at 1100 Wilson Boulevard. And I am writing my speech for that meeting. And I handed in my motion to Judge Burroughs. Yes, you know all that. Oh, and Strickland, who called up on the phone instead of writing a grown-up legal paper, got in an affidavit in opposition, and so therefore Glennie had to get in a reply affidavit, and I have to read you that. Glendora, being duly sworn, deposes and says, first of all, you must keep the microphone out of the drawer and onto your tie. Her reasons follow for making this reply affidavit in further support of her motion to enjoin Robert M. Kalaji from collecting his costs until he ceases to prevent Glendora from collecting her costs. Glendora objects to Allison Strickland's intruding. She is not familiar with the facts and circumstances of this case. Her paper should be struck from the record. She is not qualified. Kalaji is hiding behind her apron strings. He is not doing his duty and never has. Strickland lies. I am fully familiar with the facts and circumstances set forth herein. The return date of the motion was 8 days after the submission date, or April the 15th, 1995. Glendora reserves and resubmits the motion today. She reserves and resubmits the motion today, April the 18th, 1995, with a return date of April the 27th, 1995, Thursday. On April the 11th, 1995, Glendora would not talk to Strickland because 1, she is not qualified, and 2, she should put it in writing. Strickland writes, the notice of motion plaintiff served on this firm does not set forth the return date of the motion. When I called the plaintiff on April 11, 1995 to ask her when the return date was supposed to be, I played that recording for you last week. She hung up on me after I identified myself without even allowing me to ask the question. She leaves out the fact that she's really shouldn't be on the case. Glendora says she is always whining. You should know enough to put it in writing. She should know enough to put it in writing. Strickland writes, the motion is utterly without merit. Plaintiff asked this court to enjoin Gannett from collecting the costs. This court has awarded it because she has been unable to collect costs in a completely unrelated case, Glendora versus Cofault Cablevision, where, in fact, no costs are due. Glendora says this is less than candidate. It is cheap, grubby Kalaji who dishonestly kept Glendora from collecting her victory costs in Glendora versus Cofault Cablevision for breaking New York Executive Law, Article 28, 829.3, no cable operator shall exercise editorial control over public use of channel, plus a host of other laws, state and federal. Glendora is entitled to costs as a matter of statute, but Kalaji robbed her of her costs of less than $1,000. And he did this not just once, but he did it twice. Kalaji showed no irreparable harm. The week Kalaji cheated Glendora out of her costs the first time was the week Cablevision bought Madison Square Garden for $1.1 billion. Strickland writes there is absolutely no legal authority to justify any such relief, nor does plaintiff deserve any such relief. Glendora says you should be able to see why I won't talk to her over the telephone. For other than the reasons stated already, Glendora cannot stand her. She is a fee sucker and sold her soul for a cheap price. Until she returns to what a human being should be, especially during Holy Week, Glendora will not talk to her and she cannot be trusted. Everybody around the Westchester County Courthouse said they never heard of such a thing as not collecting costs when you win a lawsuit. Strickland writes, merely complains that she should not have to pay costs because she is a pro se litigant. Ironically, she requests preferential treatment because of her pro se status when at the same time she complains bitterly that pro se litigants are not treated equally by the courts. Isn't she puerile? Glendora replies, again, it is a bleak day when a court charges a pro se costs. The borough's Devlin Court never should have awarded costs, just as Judge Bryan in the United States District Court, Southern District of New York, did not award Kalaji costs February the 18th, 1994, when he dismissed Glendora's complaint against Cablevision. It would have been easy enough for the borough's Devlin Court to have stated, as Judge Bryan did, no costs. Remember that Gannett's assets are $3.5 billion. It is David and Goliath. Glendora appealed Judge Bryan's order of February 18, 1994 in the United States Court of Appeals, Second Circuit, and won. And here's a copy of the opinion, and that's I enclose the Federal Reporter. When he dismissed Glendora's complaint against Cablevision. It would have been easy enough for the borough's Devlin Court to have stated, as Judge Bryan did, no costs. Remember that Gannett's assets are $3.5 billion. It is David and Goliath. Glendora appealed Judge Bryan's order of February 18, 1994 in the United States Court of Appeals, Second Circuit, and won. And here's a copy of the opinion, and that's I enclose the Federal Reporter. Maybe it looks better upside down. Now, this is twice a pro se has won over this Park Avenue law firm. When the Second Circuit vacated and remanded Judge Bryan's decision, they did so without cost. So Glendora pro se gets ripped off again. The only costs the federal courts allow are printing costs for briefs. That would be $200. Glendora got ripped off because she believed the lie the schools are teaching your children and grandchildren today. Courts are halls of justice. But alas, they are not. They are caves of industry where lawyers and judges and court stenographers try to make as much money as they can at the expense of justice. Strickland writes, She, Glendora, merely complains that she should not have to pay costs because she's a pro se litigant. Ironically, she requests preferential treatment. I'm putting this in twice because I have two different answers to this. Both of them very good. Because of her pro se status, when at the same time she complains bitterly that pro se litigants are not treated equally by the courts. Well, Glendora says this is another lie and another soul seller. Glendora maintained that Kalaji should be enjoined from collecting costs just the way he kept Glendora from collecting her costs, not once but twice. There is absolutely no legal authority, Strickland says, I quote this twice, because Glendora says there is absolutely no legal authority to justify Kalaji's robbing Glendora of her costs in the Cablevision case, not once but twice. Strickland writes at page 41 of her paper, she states that entry of the judgment was not personally served on her. But there is no requirement that a judgment be personally served. Glendora answers, a pro se knows better. There is. Strickland is wrong again. Strickland writes she does not dispute that the judgment is valid and enforceable. Glendora says that is wrong. Glendora does dispute valid and enforceable. Can you see now why Glendora cannot stand Strickland? Glendora still wants to take this to the Yonkers City Court. Strickland writes, in sum, there are absolutely no grounds to support the relief plaintiff seeks. Glendora says she has given grounds and that Strickland has not given grounds why Kalaji should not be enjoined from collecting costs when he manipulated Glendora's being enjoined from collecting her costs, and this was not once but twice. Strickland writes the motion is frivolous. Glendora affirms the motion is very serious and its determination will live in the archives forever and will be on TV for a long time. What is frivolous is Strickland's babbling in this puerile opposition paper. Strickland writes plaintiff's behavior so reprehensible Glendora refutes this is a lie. Even if it were true, it is irrelevant to the case at bar. It is Kalaji's and Strickland's behavior that is reprehensible, getting Glendora's costs enjoined and hiding behind each other. It is Strickland's behavior that is reprehensible with her immature rattle paragraphs 1 to 6. Frivolous and reprehensible, quote unquote, shows you how desperate Kalaji is for an opposition. Frivolous and reprehensible, quote unquote, are recorded announcements with Strickland and Kalaji. They abusively with these two words, but it has never won any cases for them. Her paragraph 6 proves Glendora's point. This action was commenced before she was born. That's what I say about Strickland, that this action was commenced before she was born. Did not Glendora tell the borough's Devlin court they were fee suckers? Because she wants that defendants should be awarded their fees and costs required for preparing a response to this meritless motion. Strickland's signature has grown much older in the last month. So has Kalaji's face. It is Dorian Gray. It is the ground they lost in the Judge Bryant court, March the 24th, 1995. Glendora has no objection to a SIR reply if the court allows one. Kalaji is the attorney of record and should come out of hiding and not push an interloper before the borough's Devlin court, especially such an inexperienced one. Before the Second Circuit, Kalaji hid behind Mark Fowler, former chairman of the Federal Communications Commission for 8 years and now with Satterley. But Glendora beat Fowler too and won that case. Now again, even though she won, she was not awarded costs. Courts are the worst consumer ripoff in America. Glendora wins twice and receives no costs, but you award Kalaji costs when there is no reason to. Mary Natoli, your court clerk, told Glendora that someone told her Glendora was awarded $1,100. This is not true. Glendora has never been awarded costs or damages for anything. All she and Franklin had done is pay out $12,000 on a wild chase for justice under the belief of the lie taught us in schools, go to court and find justice. Glendora will always choose being a pro se over becoming a liar. She can stand before God all day morning tonight and know that she never sold her soul. Wherefore pages 1 to 11 do state Glendora's reasons along with her motion why Kalaji should be enjoined from collecting costs, or why he should never collect costs until he stops preventing Glendora from collecting her costs in the Judge Silverman court. Glendora also asks this court for any further and different relief this court deems fit and proper. Dated White Plains, New York, April 18, 1995, yours in truth, Glendora. And who notarized it? Francis Harrison. And who served it? Franklin Buell. This is Glendora's speech before the management and the shareholders of Gannett Company Incorporated at the annual meeting coming up on May the 2nd. Hello, my name is Glendora. Chat with Glendora, Glendora TV ads, Glendora Happy Book, and a Glendora Cheerful Look at Life on 11 different cable systems in the New York metropolitan market: TCI, Cablevision, Continental, Time Warner, Continental. And here is today's joke. Did you hear about the dentist who married the manicurist, and now they fight tooth and nail? We got up at midnight and set sail at 2 a.m. from White Plains, New York, south on I-95 to get here at 10 a.m. for this annual meeting, and this is the third year that we've done this. We will back home tonight at midnight, 48 hours, 600 miles, and 2 tanks of gas. Also, I can read you this 3-minute chronology. There is a report on TV every week about this bad management of Gannett, Glendora versus defendants, Gannett Company Incorporated, Gannett Suburban Newspapers, John Curley, Douglas McCorkindale, Gary Watson, Gary Sherlock, Lawrence Beaupre, Kenneth Paulson, Mitchell Broder, Merrill Harris, Seth Harrison, and 2 departed employees, Evelyn McCormack and Kevin Gray. Your names are on the TV screen in color throughout the reports. This week is chapter 124. Often the reports last 30 minutes. This has gone on for 4 years. 52 weeks a year. The record is read every week, and the record is bad. First, you breached a contract. Mitchell Broder interviewed Glendora for 6 months. Took 30 hours of her time, spent 2 mornings interviewing her in person, and Seth Harrison took 3 hours to take 100 photos of Glendora, and Broder turns prima donna and cries, "I may not write this story." Glendora told management, but bad management did nothing, and Broder is still wasting the shareholders' money, and you paid more shareholders to your paid liar to cover up your liar. Next, you failed to give a true account of a judicial proceeding. Kevin Gray lied, never got both sides of the story, and committed libel, flunking journalism 101 all the way. And more shareholder money went to more mercenaries, a Park Avenue law firm. You are in violation of the Sherman Antitrust Law and the Clayton Act in the Westchester suburbs north of New York City. Classified advertising rates are out of reach because of monopolization. A person had to pay for coverage he does not want. I wanted just White Plains, and I had to pay for 40 towns I did not want in Westchester, Putnam, and Rockland counties to place a classified ad. Because Gannett operates as a monopoly, the newspaper does not bother to get the other side of a story. They print one side, and the public is not informed of the other side, flunking the basics, flunking journalism 101. One time a reporter wrote about an accident on Westchester Avenue and never gave the name, age, address of the drivers. And the news they do report is not complete. The reporter covering the Harrison Town Board meeting left the meeting at 9 p.m. Before all of the great big Harrison Town fights started. So a person reads the newspaper the next day and really doesn't get the news. Judges and political bosses beg for Gannett's endorsement every election, because if Gannett gives them a bad report, there is no other forum. Consequently, this monopolization of the news scene in Westchester precludes a fair court case against Gannett. Judge Broderick's decision is the 9th such decision by a judge afraid of Gannett. And of course, we have the documentation for that, which you have seen many times, in which I will show them down there. Here's Lowy bragging about her endorsement by Gannett. Here is County Courts, West, Lange. All of these judges grovel for the Gannett endorsement. Coppola, DiBiase. Display advertising is out of reach. Defendants conspired how to ruin the newspaper competition in Westchester, Rockland, and Putnam. And because of their monopolistic control over the whole area, they will not print letters to the editor that are opposed to Gannett. GCI, Gannett Company Incorporated, has refused to print 8 letters Glendora submitted to them. They do not tell both sides of an issue. So it's a very poor excuse for a newspaper. To court, the Harrison, New York Town Court, the Supreme Court of the State of New York, County of Westchester, the Appellate Division, Second Department. I mean, it's nothing to sneeze at. To the New York State's highest court, the Court of Appeals, Glendora has taken Gannett suburban newspapers, Curley, McCorkindale, Watson, Sherlock, Paulson, to the United States District Court, Southern District of New York, the United States Court of Appeals, Second Circuit, and to the United States Supreme Court. She cannot win, and the reason why is that Gannett is a monopoly. They are the only game in town. The judges and their political bosses need that Gannett endorsement at election time. So judges rule for what is best for judges. Decisions have nothing to do with justice, right, good, and true, and valiant. All that is left is that your cheap, grubby lawyer, Robert M. Kalagi, fee sucker, is trying to collect $535 cost from Glendora pro se when he got Judge Silverman to rob Glendora of her costs of less than $1,000 twice for her victory over Cablevision. Kalagi did this the same week that Cablevision bought Madison Square Garden for $1.1 billion. Glendora's never heard anybody in Westchester County say anything good about Gannett. Over 6,000 pages. Mailings have been sent to you, apprising you of this terrible chronology, the same records that are read on TV, and you have never answered, and you have never done a thing about it. And to whom do these mailings go? Everett Dennis, Center for Media Studies, Columbia University, John Consoli, editor and publisher of Editor and Publisher, Arthur Ox Sulzberger, owner of the New York Times, Matt Storin, editor at the Boston Globe, Rosemary King, clerk at the Harrison Town Court, Joan Connick, Columbia University School of Journalism, John Lewis, who is a director and I guess the largest shareholder of Gannett. I'd like to know why we never hear about John Lewis anymore, and why is it his wife, Josephine Lewis. Hey, they go to Chief Judge Judith Kay of the state of New York, and to John H. Clark, lawyer of the Antitrust Division, United States Department of Justice in New York. And they used to go to Judge Vincent Broderick, but he died. And they go to Magistrate Judge Fox. The end. Her up is the New York State DHCR, Stephen Cohen, and Gary Friedland, Myron Holtz, Virginia Diaz, and well, there's quite a few others. The White Plains DHCR and the Manhattan DHCR on William Street. Nothing happened this week. We're waiting for the decision of the Appellate Division, Second Department, State Supreme Court of State of New York, and that probably won't be in for another week or so. And what is happening on the Lawbreakers, the Fund for Modern Courts? Elizabeth Hubbard, Alan Beck, Michelle Mayapath, and their lawyer Edmund Purvis, and Judge Colabella, the court where there's no justice, just malice. Nothing. We think what is pending is that Purvis over in Larchmont has to get in a respondent's brief to Glendora's appellant's brief. And then Glendora gets in a reply brief, that's it. Glendora has the last word on that, and then that sits for a year until the Appellate Division can schedule an oral argument and then make a decision. And that brings us up to the law-breaking of Andrew Larkin, Kevin Larkin, James Walsh, Roberta Walsh, Daniel Walsh, Nella Alpucci, Theo Alpucci, the lawyers Wilson Bave, Conboy, Koza Cousins, Odell McGrath, Karamitsos, and Stephen Carlucci, law clerk, and Judge Wood. Tom Wolfe, not the very, very famous author of You Can't Go Home Again, but Today's Tom Wolfe. He worked on the same newspaper that Franklin did for a few weeks. He knew he wanted to be an author, but he wanted some newspaper experience. And this was the Springfield Union in Springfield, Massachusetts. But anyway, I want to read something that he said about day-to-day sources of stress to the public. Vagrancy, truancy, and excessive noise. They are only misdemeanor crimes or are treated as mere nuisances by the criminal justice system. And you all know that that's what we're standing up for here. Other law breaking, the wall logs got way behind, but they did get out last Thursday and finally got distributed on Friday. The costs are the same, or horrible. You saw the murdered grass. That would be by the girls in 3D, 4D, and 2B. And it's too bad. They were told not to do it. They were told what the result would be, to murder the grass down to a bald spot of mud. But they continued to violate the law and do it. James Walsh is banging up the stairs, coming down and up every day, 2 or 3 times a day in roller skates. Now that makes a lot of sense, doesn't it, to go up and down stairs in roller skates. You really have to be a special kind of a stupid to do that. The full moon is beautiful out the west door of A. Instead of having an Easter sunrise service, we had an Easter moonset service. There's a cigarette burn on the new washing machine, the new computerized washing machines. This is grounds for eviction. This is destructive of the landlord's property and is taking away other tenants' rights. Roberta Walsh does not appreciate the nice things that the landlord gives us. The cellar window is broken. They've been told about it 4 times and it should be fixed. There's litter on the cellar floor. Glendora cleaned it up. There was soap powder on the cellar floor and Glendora cleaned it up. There's water on the cellar floor and the building department has told the landlord to take care of that 2 or 3 times. Also, the garbage cans are overflowing. And it was exactly 2 weeks ago, Easter, that all of this started. And what started it? It was the breaking of the law of the Walsh, Alpucci, and Larkin families. On Easter 1993, the White Plains Noise Ordinance. Yelling, shouting, hooting, whistling, or singing at any time or place so as to annoy or disturb the quiet, comfort, repose, health, or peace of persons in any dwelling or other residence. That is the law that was broken initially. And when Glendora stood up for her rights and began videotaping her evidence, instead of reforming, said Hoonland started a long campaign of retaliation, more law-breaking, harassment, vandalism, thievery, abusive and insulting language, horn-blowing fright, mental disturbance, and littering. Now they go to trial shortly. I wonder if James Walsh is going to wear his roller skates to trial. They take the stand. Remember Daniel Walsh saying to the Eyewitness News, "I'd like to get Glendora before a judge so we can tell him what she's done. We have been before a judge 1 year and 6 months, Daniel Walsh, and you haven't told anything to the judge." Now he will have to tell a judge and a jury. "I was so ugly," Pete said, "when I was a kid. When I told my parents I was going to run away from home, they asked me to put it in writing. And when we played hide and seek," Pete said, "the other kids would not look for me." There is nothing to tell a judge and a jury about Glendora because she was careful never to break a law. It's smart not to break laws. It's stupid to break laws. It's stupid then to lie and cover up. It's stupid to go on breaking the same laws over and over again. At 6:39 a.m., the nice electronic dryer is broken Sunday morning. The digital says door, door, door. That's because people slam the door instead of shutting it gently. And instead of putting the whole load in all at once, they keep opening the door and they put in one article, and slam the door, open the door again, put in another article, and slam the door. This is all in one washing, and they do that about 10 times. A superintendent would have got the dryer repaired Saturday, so we had to put the wet laundry into the Lincoln and drive to Mamaroneck Avenue and dry it. John Porzio owes us 75 cents we put in the abused dryer, now non-functional. That was 1.5 hours to finish writing the motion to Wood to vacate the grotesque decision of March the 23rd, summary judgment Larkin. Franklin typed 5 pages. James Walsh is coming down the stairs at 4:20 p.m. on his roller skates again. James Walsh goes up the stairs on roller skates again at 5 p.m. At 5:04 p.m., James Walsh comes down the stairs on roller skates at 5:04 p.m. File, paginate, log, and the mailing for Walsh. And the number of tortious acts, i.e. injuries, is 2,784. The number of hours is 13 3/4 on this law-breaking, and the costs this week were $36. At 6:17 p.m., James Walsh goes up the stairs again in his roller skates, stupid. And the dryer door is working. Who fixed it? This is the list of people to whom this mailing goes every week. Walsh out there calling Jamie, and Jamie left over an hour ago on his roller skates. Did you hear about the minister who was so religious that even his contact lenses were stained glass? Monday at 1:30 p.m. I was standing at the curb waiting for the Lincoln to pull up, and James Walsh called from his kitchen window, "Quack, quack." And at 1:40, as I was getting into my car, James Walsh mocked, "Glendora, how would you like to live with somebody like that?" Grounds for eviction, grounds for eviction. It's stupid to keep breaking the same laws over and over when James Walsh is going to trial. Roberta Walsh blasted her horn at 2:36 p.m. Tuesday, April the 18th, 1995, into Glendora's dining room window. That's grounds for eviction. Get them out of here. The wall log was posted on Wednesday. The motion for Judge Wood to vacate that grotesque decision, dismissing the complaint against Larkin, the motion to vacate that was served. And I'll read that to you in just a moment. 5:34 p.m. on Wednesday, James Walsh clunked up the stairs outside Glendora's door in roller skates. David Bragg in college, I had the women running in circles, and his mother-in-law says, "That's right, he was a track coach." Franklin has gone to the DHCR on a 3rd trip. The people down there have been very knowledgeable, and they've told him about renewing the lease. These are all of the questions that we take down to the DHCR, and he gets them answered. And these are the things I told you about that are so informative. And now here's the motion to vacate and reconsider the order to dismiss Glendora's complaint. This is Glendora plaintiff versus Daniel Walsh, James Walsh, Roberta Walsh, Nella Althucci, Theo L. Pucci, Andrew Larkin, and Kevin Larkin. To Harold L. Wood, please take notice that upon the annexed affidavit of plaintiff Glendora sworn to April 18, 1995, and upon all pleadings and prior proceedings held herein, plaintiff will move this court before Judge Harold L. Wood at the County Courthouse, 111 Grove Street, White Plains, New York, 10601, on April the 27th, 1995, at 9 a.m. or as soon thereafter as plaintiff can be heard, for an order: vacating the order summarily dismissing Glendora's complaint. B, vacating the order that Glendora pay costs and disbursements. C, vacating the order threatening sanctions. D, making a new order declaring the Larkin branch of the case ready for trial, awarding Glendora costs and disbursements, imposing sanctions on Wilson, Babe, Comboy, Koza, and Cousins, Odell, McGrath, and Karamitsos, awarding Glendora any further and different relief this court deems just and proper. White Plains, New York, dated April 18, 1995, Glendora. And also to Bruce Bendish. Glendora, being duly sworn, deposes and says her reasons follow for Judge Wood to vacate and reconsider the decision order of March 23, 1995, dismissing Glendora's complaint. 1, your decision order is so blatantly political. 2, you do not have a leg to stand on. If there is a dispute of facts, how can you grant summary judgment? 3, the court and the Babe, Comboy, Koza, Cousins, McGrath, Odell, and Karamitso's lawyers have made fools of themselves in public. They have done this all over the state. Other than its being a ridiculous motion written ridiculously and childishly by Alexandra Karamitsos and the decision order being ridiculous, it is dangerous. Glendora will tell you frankly that if you don't rule on justice instead of on political ties, she is going to initiate a flock of proceedings that will be distinctly worse. Since March the 23rd, 1995, Glendora has been waiting for the answers to come to her as to what to do about this incredible decision. Last night the answers came. First, appeal Judge Wood's grotesque decision order to the Appellate Division, 2nd Department, April 22nd, 1992. That's going to be done today, Thursday, because you don't want to wait until the weekend. Next, sue Andrew and Kevin Larkin in the White Plains Police Department in the City Court of the City of White Plains for their outrageous violations of the White Plains Noise Ordinance, all on videotape, for $28,000. Next, sue the Wilson law firm Babe, Comboy, Koza, Cousins, McGrath, Odell, Karamitsos, sue General Accident, sue Judge Wood and Stephen Carlucci, the law clerk, sue Andrew and Kevin Larkin in the United States District Court, Southern District of New York, in the brand new courthouse for violation of due process and my constitutional rights under the 1st, 5th, and 14th Amendments. Jurisdiction is by color of state pursuant to 42 United States Code, Section 1983. And for millions, not just thousands, but this time for millions. Wilson Babe have it, General Accident has it. This would not be an Article 78 proceeding, although that is a possibility too. The dismissal of March 23, 1995 is an odious note for Judge Wood to leave upon. If he wants to be a JHO, Judicial Hearing Officer, and apparently he does, as evidenced by his political submission to the wild lawlessness of Wilson Babe, Convoy, Koza, Cousins, Odell, McGrath, and Karamitsos, and Glendora will virulently oppose any such appointment. Appellate Division Judge Charles Lawrence died April the 3rd, 1993, Send not for whom the bell tolls, it tolls for thee. Glendora will test your political ties in White Plains City Court, Yonkers City Court, and the United States District Court, Southern District of New York. Judge Wood has been Send not for whom the bell tolls, it tolls for thee. Glendora will test your political ties in White Plains City Court, Yonkers City Court, and the United States District Court, Southern District of New York. Judge Wood has been led around by the collar and leash by Wilson Babe, Koza, Comboy, Cousins, Odell, McGrath, and Karamitsos. Take a look at the following. No default judgment on Wilson Babe at all, answering 5 weeks untimely, a summons with notice and complaint, and Judge Wood ignores this. No granting of 3 orders to show cause by Glendora for protection against injuries by law-breaking defendants, as the Judge Wood Court takes forever on this case. Allowing Koza a second deposition after he bungled the first, a matter of record. Allowing discovery of videotapes a year and a quarter too late, just as a device to wear Glendora down and to delay. 19 out of 20 decisions by Judge Wood unilaterally in favor of the crooked Wilson Babe gang. Allowing Koza to lie 3 times about the new Larkin address. The new Larkin address is something like 58 Condit Avenue or Street in Harrison, New York. And Koza was in Koza was in violation of Article 31, the discovery rules of the CPLR. And Comboy was in violation because he dodged the insurance agreement. That would be Article 3101F, I think. And there are more giving rise to the TV graphics superimposed over this account. Crooked lawyers and corrupt courts. Glendora Officer Larkins a settlement figure of $28,000 cash all at once, wired to her bank account by May 15, 1995. Otherwise, you will be sued for millions in federal court where they don't fool around the way they do in Westchester Supreme Court. Glendora reiterates and incorporates by reference each and every allegation stated in her summons with complaint of November the 11th, 1993, in her motions, cross motions, 127 mailings, exhibits, her show cause papers, her conference minutes, her depositions, and her protests, as if fully set forth herein. You know you acted badly as lawyers. You made a decadent profession look worse. You know you cheated the shareholders of General Accident. Judge Wood knows he violated his ethical duties, vitiated his oath, and disregarded clear and controlling law, and wrote fabricated decisions that were self-serving. Law clerk Stephen Carlucci knows this. Glendora and Franklin know this. You know this. And all the people around New York Courtland who have received the logs know this, and Glendora has made sure the public knows this through her television program and will continue to do so. The public has to know, and God knows this. The hoax is up. It is time to straighten up and fly right. The incompetence, corruption, and selling of soul for a cheap price have spewed havoc and crises on the public's courts. Wherefore, pages 1 to 4 herein do state the reasons plaintiff Glendora, appellant soon to be, pleads that this court grant an order vacating the order, summarily dismissing Glendora's complaint, vacating the order that Glendora pay costs and disbursements, vacating the order threatening sanctions, making a new order declaring the Larkin branch of the case ready for trial, awarding Glendora costs and disbursements, imposing sanctions on Wilson, Babe, Comboy, Koza, and Karamitzos, awarding Glendora any further and different relief this court deems just and proper, dated White Plains, New York, April the 18th, 1995. Yours in truth, Glendora. To Wilson, Babe, etc., Bruce Pendish, and the notary is Francis Harrison. And this went to Gary Casala, Grievance Committee of the 9th and 10th Judicial District, a do-nothing if there ever was one, Chief Judge Judith K., Judge Joseph J. Trafficante, Office of Court Administration for the courts outside of New York City, Judge Angelo Ingracia, our administrative judge here in Westchester, Orange, Rockland, Putnam. Gerald Stern, the New York Commission on Judicial Conduct, who is being sued, and I'm going to join in on it. And Chief Administrative Judge E. Leo Malonis, who is the Office of Court Administration in New York City, and to Walter E. Farnham, CEO, General Accident Insurance Company, 30 Sleepy Hollow Drive, Newton Square, Pennsylvania, 19073. Enclosed also was the case that Glendora won against Cablevision, reported in the Federal Reporter. And where do you go when judges break the law? Put up the number, please, for the Center for Judicial Accountability. Statement of purposes of the Center for Judicial Accountability. The end. It says, but Mother, my boyfriend doesn't have many faults. And Mother says, no, but he makes the most of the ones he has. And Diana says that she's a real nature lover in spite of what it did to her. And Hazel says about our son-in-law, he's like a blister. He never shows up until the work is done. Michael Gelman. As for Michael Gelman, producer of Live with Regis, in a lawsuit for $380, justice is stopped because the minutes cost $740. The lawsuit is a lawsuit suing him for $380. The wrong decision was made in the small claims court in Manhattan, and so I have to appeal that decision. I have to stand up for what is right, and to appeal the decision, I have to pay $740 for the minutes. What do you think of that? All right, civil court of the City of New York, County of New York, Small Claims Part, Glendora plaintiff against Michael Gelman, defendant, Judge Silberman. Plaintiff Glendora is having a real problem with this appeal. She sued for $380. The minutes are $740. There is no way we can afford $740 for minutes. Glendora wants to appeal. She wants to stand up for what is right. She doesn't want the state to pay for the minutes. It is too big a taxpayer expense. So the expense of the minutes is keeping Glendora from justice. That should not be. Glendora has asked the court stenographer, Lisa Kaplan, to give a price for just those parts of the minute that deal with Glendora's asking to submit her audio tapes as evidence, followed by the judge's refusal, and that deal with Glendora's asking to submit her logs as evidence, followed by the judge's refusal. The rip-off in the courts on stenographers' minutes has been a sore point with us for years. We paid $1,430 for minutes for the appellate term, 9th and 10th Judicial Districts, and Judge DiPaolo, Ingrassia, and Collins never read them. From the oral argument, it was evident they had not read them. This was a case where Glendora sued for $3,000 and paid $1,430 for minutes. There is obvious collusion between courts and stenographers to keep the swindle going. A court could allow litigants to audio tape the proceeding and to make their own transcript, which could be settled with the other side. That would cost about $20. An audio tape is a much better record anyway because it shows inflections, tone, and meaning, and it is more accurate. So many times there is error of hearing or of meaning in a stenographer's minutes. You've seen that over and over again in these minutes that I paid so much money for and read to you. The big point here is that cost of minutes obstructs justice. That just plainly cannot happen. That cannot be tolerated. And the court stenographers don't fill up the page. They charge $5 a page, and there are wide margins left on the side and on the top and the bottom, and this much space between every line, and this much of the line is as to who is saying it. Glendora sees this as an urgent area for court reform. This has to stop, along with judges with no judgment. Here is a possible dissolution for this issue. CPLR 5525B says, omission of part of the transcript. The parties may stipulate that only a portion of the record be transcribed. No transcript is necessary where a party appeals from a judgment entered upon a referee's report or a decision of the court upon a trial without a jury, and that's certainly what I had, a trial without a jury. And he relies only upon exceptions to rulings, and that's exactly what I'm doing, relying on exceptions to ruling. I took exceptions to both of Judge Evans' rulings on questions of law made after the case is fully submitted. So, and here's some cases in law about that, case law. So, it is hereby stipulated, this is the stipulation I wrote, by and between Glendora, plaintiff appellant, and Michael Gelman, defendant respondent, in the above entitled action, that only the following portions of the stenographic record of the proceedings at trial of the above entitled case, February 23rd, 1995, be transcribed. 1. Those statements by plaintiff and judge where plaintiff asked for audio tapes be admitted as evidence and the judge denied same. Those statements by plaintiff and 2. Judge where plaintiff asked for her handwritten log to be submitted as evidence and the judge denied same. 3. Plaintiff's taking exception to both of those rulings. Dated April so-and-so. I haven't sent it yet, to be signed by Glendora and by Michael Gelman. Another possibility in this quest for quick solution of quandary, that's what I call this, quick quest or request for quick solution of quandary is Glendora applies in form of papyrus. But she does not like to see the state get ripped off $740 for this excessive charge for minutes, precluding justice from being done by preventing an appeal. Following is Glendora's motion for informa papyrus to the Supreme Court of the United States. And you remember that. I read it to you at the time, back in February and in January. Then there is CPLR 5527, statement in lieu of record on appeal, when the questions presented by an appeal can be determined without examination of all the pleadings and proceedings, the parties may prepare and sign a statement showing how the questions arose and were decided in the court from which the appeal is taken, and setting forth only so much of the facts averred and proved or sought to be proved as are necessary to a decision of the question. Well, the grounds for appeal are: 1, oh wait, these footnotes are kind of interesting. The advantage is to save costs. Alternative methods of prosecuting an appeal in the appellate division, the second department. That's our department. Oh, no, this is in the first department. This is downtown. The grounds for appeal are: 1, Glendora's audio-taped evidence was not heard by the trier of fact, that would be Judge Evans, and 2, Glendora's log over 5 years was not heard by the trier of fact. Glendora feels these 2 would prove her cause, her case, breach of contract. Glendora took exception to both of these rulings by Judge Sarah Lee Evans promptly, the instant these rulings were made, as unfair and illegal. Objections were made to these issues in question during the trial. Glendora's rights were substantially affected. The fairness and integrity of the judicial system were undermined, causing a miscarriage of justice. An appellant cannot be denied an appeal because of excessive charge for minutes. The courts are not an industry. The courts are not an industry for lawyers and court stenographers to see how much money they can make out of them. Courts are for justice. Something has to be done by this court on this quest for quick solution of quandary. Dated White Plains, New York, April blank. That's got to get out. It's been here long enough. And here are the affidavits of service. And that's Glendora versus Michael Gelman on a matter of $380 just because he didn't have the ethics or the common sense to return a person's property. I sent him 2 videotapes and he just didn't return them. And so he spends all this money on lawyers and all of his time lying and covering up, just like the rest of these common crooks. I'd like to make an announcement in behalf of the Center for Judicial Accountability. I would like to have you join. Why don't you call this number and find out about it? To go to school, folks, with his dog. It was awful cute. Every morning they'd go off to school together. Every afternoon they'd come home together. And after years and years of this, it was finally over. The dog graduated. And Sally said about her boyfriend, "But Mom, he's just a guy trying to get ahead." And Mom says the sooner the better. Speed reading. John took a course in speed reading and it really helped him a lot. Now he moves his lips twice as fast. Here's what page, these aren't my minutes, these are somebody else's minutes. I'm using up the back as scrap paper. They were in the wastebasket. But look at that. Look at that. Look at all the space that's wasted. And yet they charge you by the page. And they put as little on a page as possible. Rip off. Yonkers courts, which are really, I like them. I like the Yonkers courts. They have a beautiful courthouse, the Robert Case Justice Center, and they have 6 parts, and the courtrooms are beautiful. But a change for the worse, they've got rid of the Yonkers policemen, and they put in New York court officers. And I like maybe 1 out of 4 New York court officers. that I have met. They're usually very arrogant and very overbearing and really obnoxious. So, and then they took out the parking attendant there at the municipal lot and put in a machine, and we can't understand it. There were, out of 6 judges, 5 of them were not on the job. There was one hard-working judge there, a judge that I like very much, Judge Noka, who is almost totally blind, but he's a good judge, and he was working hard. And of course, what was the case? What it is always when you go to court, a young black male on substance charge, selling dope. Every time you go to court, it's a young black male charged with dope peddling. It is so sad. Judge Noka, unfortunately, didn't have a nameplate on his bench, and every judge should have his name on the bench. I don't think that that's discretionary. I think that's mandated. Has the right to know the name of the judge at the bench. Oh, yeah. And these obnoxious court officers, New York State court officers, see all over the state now, Malonis and the Office of Court Administration has put New York State court officers in the courts, even in White Plains. And they are so overbearing. I really can't stand them. Yonkers, this court officer asked me what my business was. It's none of his business what my business is. Courts are a public process. Courts are open to the public. He has no right to ask you that. And then another court officer came over, and he was sort of good looking. He was completely bald like Telly Savalas, but he had beautiful blue eyes. And he says, can I see some ID? And I really hurled it at him, you know. I told him that courts are a public process. By the Constitution of the United States, any litigant is guaranteed a public trial. It's not a public trial if the public isn't there. So this court officer ought to go down to Mr. Malonis, the Chief Administrative Judge, Office of Court Administration down in Manhattan. He ought to learn the Constitution of the United States and qualify as a New York State court officer. I can tell you that today is the day I'm going to file a notice of appeal of Judge Wood's political decision on dismissing my complaint against Andrew and Kevin Larkin. And so that has to be filed today. I don't want to do it. That's another 2 years of litigation. It's another $1,000. It's another 500 hours work. It's much more stress and strain and disturbance. You get into these, just because there's no justice in the courts. If there were justice in the courts, these things wouldn't go on and on ad infinitum. But because there isn't, they go on and on and on and on, and you get sucked into it and you can't get out. It's worse than flesh-eating bacteria. Mexico is having its annual meeting, shareholders meeting, I believe, May the 9th. Just a second, I'll tell you for sure. Yes, Tuesday at 10 a.m. at the Rybrook, the Rydtown Hilton. And this is my admission ticket. And I just want you, you got to give them credit. Look at this annual report. It is beautiful. If you could only see it in person. Isn't that beautiful? And I told them they gave us place for a comment, and I said, Texaco should sponsor Glendora, a cheerful look at life on the NBC television network every Monday night, prime time, for 1 year. The cost is $14 million. Glendora tells 3 jokes, and at the end she says, this 30 seconds of goodwill and good cheers brought to you by Texaco. Xerox sponsored it, as did Texaco back in September 1989. So did General Foods, Quaker Oats, and Polaroid. You would endear 14 million people 52 times equals 1 billion impressions to Texaco. Now, The shareholders' proposals, stockholders' proposals. Let me read them to you. This is the proxy statement. I talked to Carl Davidson yesterday. I'm going to read you these shareholders' proposals. They're pretty interesting and they're good, and I voted for every one of them. A stockholders' proposal relating to classification of the Board of Directors. The Board of Directors, of course, wants you to vote for the directors that they've nominated, and they want you to vote, of course, for their accounting firm. So you say no to both of those. That the stockholders of Texaco request that the Board of Directors take the steps necessary to declassify the elections of directors by providing that at future board elections now, new directors be elected annually and not by classes for 3 and 4, 5, and 6 years. Yes, they should be elected annually. Okay. Now let's find the next one. This is the proxy statement. Naturally, the Board of Directors says, no, don't vote for them. That's item 3. Item 4. We believe financial, social, and environmental criteria should all be taken into account in fixing compensation packages for corporate offices. Let me read it to you again. We believe financial, social, and environmental criteria should all be taken into account in fixing compensation packages for corporation officers. Terrific. That age is gone, America, when you had these business tycoons who ravaged the country for their own personal profit. Now, take it out of their pay if they violate the environment. And the financial status of others, and the social status of others. Now let's go and try to find item 5. We believe there is a strong need for corporate commitment to equal employment opportunity. Yes! Item 6. Texaco's corporate conduct guidelines function as the company's statement of policy governing business internationally. In it, Texaco states our company cooperates with federal, state, and local governments, promotes employee safety and health, demonstrates commitment to environment, believes a work environment which reflects diversity and is free of all forms of discrimination, respects each employee's right to engage in or refrain from engaging in activities associated with representation by a labor organization. We commend Texaco, but what is the proposal? The shareholders request the Board of Directors to review and update the Texaco Corporate Conduct Guidelines and report their revisions to shareholders and employees by September 1995. So I voted for all of those good things. This year, Gannett doesn't have any shareholder proposals. I wonder why. Mighty suspicious to me. And CBS has 6, and they're dillies. I'll try to read those to you next week. The next matter I want to take up with you, I have to cue up this audio tape. There's a terrible thing that happened yesterday afternoon. On Tuesday night, I called Kensico Auto Parts and asked them if they had any parts for a 1980 Lincoln. And he said, call tomorrow and ask for the parts, and ask the person tomorrow. I said, okay. So Wednesday, I called, and this woman answered, and I said, do you have any parts for a 1980 Lincoln? She says, no, we have no parts at all. Why would somebody Tuesday night tell you to call Wednesday and ask for auto parts? You call Wednesday and ask, no, we have no parts at all. And then she hung up. And so I called again, and then she hung up again. Now this is Kensico Auto Parts, and it's on Kensico Avenue here in White Plains, just off of Westchester Avenue. Down opposite, well, it's where there's the 2 gasoline stations and the fast food shops. They're not fast food, but you know, convenience shops. I'm trying to think, Permanente, opposite Kaiser Permanente on Westchester Avenue in Kensico. Okay, so then I called back and I said, why do you keep hanging up? And then she got very vile. In fact, she got obscene. And so I called again, and then a man answered, and he says, White Plains Police Department. He's impersonating an officer. So I called again, and he says, White Plains Police Department. And so then I called the White Plains Police Department to report that here's somebody saying, impersonating his officers. And the White Plains Police Department, as ever, blockheaded, infuriating, derelict, and I just want you to hear this whole record. It's a catchy tune, isn't it? This is the call before that.
Why do you keep hanging up? Do you know who you're talking to? What's going on there? Listen, bitch, take it in your motherfucking ass. Do you hear me? Okay, and I'm going to play this back for you. Stop for tomato and lint. Then I call back, and they answered the phone, White Plains Police. Impersonation of an officer. Did you just impersonate an officer by chance?
Did I who?
Did you,
This is the police department, ma'am. How can I help you?
Oh, I bet it is. What's your number?
Huh?
What's your number?
949-3298.
I don't think so. My telephone number says that I have you on 949-3052.
I don't know what to tell you, ma'am.
Well, I think you
There's
do.
something I could do for you.
You know what to tell me? You're lying.
Something I could do for you.
You're lying. And you're also impersonating the police. And it'll be easy enough to give the police your number. And it'll also be easy enough to
Whatever you want to do, ma'am.
and it'll be also easy enough to play this recording for them. (2:17 p.m.) This is Kensico Auto Parts. And the date is April the 19th, 1995, Wednesday. And the time, again, is 2:18 p.m.